Good afternoon, everyone, and welcome to our 22nd, unbelievable to say that, but 22nd weekly Franczek webinar since the onset of the COVID-19 pandemic. For those of you who don't know us all by now, I'm Jackie Wernz, your host for our webinar today. And this week's webinar is Navigating Teacher Evaluations During a Pandemic, in which we are going to discuss all of the very complex teacher evaluation issues that we know all of you are facing right now. We are delighted to have you with us for the next hour, and thank you for joining us today and for submitting your questions during registration and during the webinar. Please use the Q&A function, if at all possible, to submit your questions, as it allows us to best keep track of them, and it will allow us to do our best to cover them all today. So today on our panel, we are pleased to have two of our regular panelists who've been here with us since day one. We have Nicki Bazer.
Hi, everyone.
And Shelli Anderson.
Hi, everyone.
We are also thrilled to be joined by our very special guest, Todd Faulkner. Welcome, Todd.
Thank you, Jackie.
And before we jump into our evaluation discussion, I want to highlight our topic for next week, which will be lessons learned from week 1 of Back to School 2020. So keep an eye out for a registration announcement in the coming days, and let us know if you have any questions or thoughts that you want to share about your experiences. For those of you who have gone back to school this week, let us know. You can reach us through the registration process, or you can always email us at allmarketing@franczek.com. And as always, if you find yourself looking for more information, or if we're not able to get to your question today, please reach out to one of us for more information. If you missed any of our webinars, you can find them all on our website under events at franczek.com. And while you're there, take a look at our many other webinars, alerts, blogs, and podcasts on a wide range of school law topics. All right, and with all of that, let's jump in. So to start, let's set the scene for our conversation today. So Todd, could you please briefly remind our audience of the general overview of evaluation requirements pre-COVID-19?
Yeah, and Jackie, I'm going to just highlight those a couple of provisions in Article 24A of the School Code, which sets, governs evaluations that really present problems and barriers to evaluation of teachers in our COVID-19 world of remote, hybrid, and in-person instruction. And those are that tenured teachers must be formally evaluated every 2 years. Non-tenured teachers have to be formally evaluated every year. Formal evaluations have to be consummated with a rating that is based on student growth data, personal observation in the classroom, at least once for a tenured teacher, and I think under most plans and ISB guidance multiple times for a tenured teacher. And then the rating must also be based on performance in multiple domains. We also have the requirements that we have to deal with or address, the requirements with respect to development and implementation of professional development plans for teachers who are rated needs improvement, and an appeals process and remediation plans for teachers who are rated unsatisfactory, or tenured teachers who are rated unsatisfactory. All of these requirements have to be addressed in the context of existing collective bargaining agreements and existing evaluation plans. And we also have to look at the involvement of the Joint Para Committee and negotiations with the teachers' unions. And all of these topics we will get into more detail, and these requirements we'll get into more detail as we move through the next hour.
Great. And so that is the normal world that we were all used to before COVID-19. And we all know that that's very different now. So Shelli, could you give us a rundown on what statutory changes to the evaluation process should people be keeping in mind now under COVID-19?
Sure. So there were a few changes that relate to kind of teacher evaluation, and also talk about discipline kind of generally in that whole process. So one of them that I think people are most familiar with is the change to Section 2411 of the school code related to what the default was if you did not complete a tenured teacher evaluation. So typically in the school code, if you are able to complete an evaluation on an area that you, or in a year that you're supposed to, the default rating for that teacher is a proficient. And there was a law that was passed during COVID that indicated that for tenured teachers, if their evaluation rating was not completed and they had a prior excellent on their last evaluation, they would actually default to an excellent unless the union and the board had made some other decision in writing as to what that process would look like. So that's kind of where we were. No indication right now as to what's going to happen for next year. We'll talk about a little bit about whether we're expecting to see any change there. But that was with respect to kind of what the default was. There was also modification in 24A5 related to the pausing of any remediation plan that had started before the suspension of in-person instruction. The piece there, though, is that that language specifically addressed that it was only paused when the governor's disaster proclamation suspended in-person instruction. So because we no longer have that portion of the proclamation, remediation plans can actually continue, either have to restart or they have to pick up where they left off, depending on how far along they were last year. So that can actually start happening in 2021. You obviously should look at those and make determinations as to whether any changes need to be made because of the remote environment that many of you are finding yourselves in. The only thing I'll say in addition to that is that there was also a change in 2412 related to the dismissal of tenured teachers. And that was also part of the proclamation that while we are under disaster proclamation, that process is also paused. So interestingly, while the remediation process can now continue, once you got to the end of that, assuming we're still under the proclamation, we are now paused with respect to if you have to actually dismiss a teacher related to that. So those are kind of the statutory changes that we're looking at that impact evaluations, at least right now.
Great. And then I know we're also going to talk about bargaining implications. So can we walk through the provisions at play in the IELRA, Todd?
Sure. It's through a series of appellate court, Illinois Supreme Court, and labor board decisions that we have our guidance. The Illinois Educational Labor Relations Act doesn't really address evaluation directly. And the way the decisions or the guidance that have come from these decisions have shaken out in a very brief summary is that the substantive topics in evaluation are not mandatory topics of bargaining, but are deemed permissive topics. And but the procedural aspects of evaluation plans are mandatory topics of bargaining. We don't have a lot of guidance on how to sort of parse between those two. We do have some identification in the cases as to what would be the substantive topics, and that they would include the performance criteria, the weight to be given to those criteria, the areas of teaching to be evaluated, and also the duties of teachers and the standards of performance. So those would all fall into the mandatory, non-mandatory permissive topics of bargaining. Permissive topics can be bargained. And if an agreement is reached on a permissive topic, it has to, the labor board has determined that it has to be reduced to writing, and that it would become enforceable through the grievance procedure and even through arbitration, unless there's been an agreement negotiated that a particular topic would not go through the grievance procedure. So, we have to be careful about beginning negotiations on a permissive topic, and because it really can turn into an enforceable, almost mandatory topic if it isn't handled appropriately in the course of discussions with the union. We also have a requirement outside the labor law but interfaces with all this, that is Article 24A of the school code, says that evaluation plans have to be developed in cooperation with the unions, and the courts have recognized that the in cooperation is different from negotiations, but they also have determined that that cooperation, that you can negotiate these items with the union. So it doesn't preclude negotiations. There's also a provision in the labor law which is very significant that we're going to wrestle with a little bit later in the discussion today, and that is that if a provision in a collective bargaining agreement or an MOU, which is what we're really talking about, conflicts or violates a provision in a statute like the school code, then it's unenforceable and void. And as I say, we'll cover that in a few minutes, but that's something that's going to permeate dealing with these issues. The bottom line is that, with the changes to the evaluation plan, we have to look at our collective bargaining agreement. We have to look at our evaluation plans. We have to figure out what pieces don't work in our COVID-19 context, and then devise a discussion negotiation plan that tries to navigate through and solves those problems.
Great. Now, you mentioned the difference between bargaining versus consultation requirements. Can you help us through the distinctions between the various committees, Nicki, RIF and para committees, and how that factors into bargaining and the standards?
Yeah, absolutely. And what I'm going to do is I'll just talk a little bit about the committees now, and I think later we're going to see how these kind of play into the mix. And I have to say, I know districts are probably much more up to speed on these committees. It took me a minute to have to go back and refresh. Those of you who are sort of dealing with this every year know that there's two different committees that really come into play when we're talking about evaluation and then the results of evaluation. So I want to talk about the Joint RIF Committee for a second. That's the committee that meets every year, right? It meets by December each year and attempts to reach agreement in terms of the groupings and the sequence of dismissal consistent with the provisions of the school code and obviously the evaluation plan of the district. They have to reach a decision by February. If they don't, then it just defaults to the statutory standards. So that's sort of one committee that's really not going to be at play necessarily in these conversations about evaluation. The second committee is the Joint Para Committee, which everybody had meet originally in the first year to develop the plan before implementation of the para-based evaluation plan. There is a statutory requirement in 24A that committee meet annually to assess and review the plan's effectiveness. But there is no, unlike in the original meetings of the Joint Para Committee, it was clear that if the Joint Para Committee did not reach agreement on various components of the original evaluation plan, that the statute required that the district then default to the model evaluation plan that was set forth in the ISB regulations. Interestingly, the provision in the school code that discusses the subsequent annual meetings doesn't reference the model evaluation plan. It doesn't reference the idea that you would then default if, say, for example, some of the committee members did not believe that the plan was effective. So that's going to factor in as we think about, we're going to talk a little bit later about student growth, having to adapt pieces of your evaluation plan and the role that committee might play in adapting that plan.
So I know that all of our guests regularly read from top to bottom all of our alerts. And if for any reason you don't receive them, definitely reach out to us and we'll get you signed up. But I do know that the three of you put out a great alert recently on evaluations. And so I'm hoping that you can walk us through what the alert was focused on and what districts need to be thinking about with respect to what was covered there.
Sure, I'll take a step of that. The alert was really to make sure that, with all that you're thinking about in terms of your bargaining and reopening and all of that, remembering that regardless of where you're at in the bargaining process, we're talking with the union about what evaluations are going to look like this year, that the school code does require that we provide notice to all teachers who are going to be evaluated by the first day of student attendance. And so the alert was focused on just making sure that those notices went out. Now, this is something that's not new to COVID. Districts have had to do this every year. So typically, you just should go back and look at what notices you provided last year and determine which teachers are on schedule to be evaluated this year. Obviously, it's all your probationary staff, and it is likely the group that was not to be evaluated last year for your tenured staff. So we wanted to make sure that folks remembered about that. They didn't somehow miss that deadline. We are recommending a small change depending upon where you're at with your union and your evaluation plan. And that is just to make sure that you will alert the teachers that the evaluation is going to be moved forward in accord with your regular evaluation plan, and then perhaps have some modifying language in there that talks about that it is also going to potentially be changed in consultation with the union and due to the work of the district's joint evaluation committee. As we'll talk about in a little bit, there might be some changes that are needed there, whether it's who's being evaluated or how the evaluation is being done, but making sure that you're being notifying teachers of that up front so that it doesn't become an issue later that you've met the statutory requirements. Now just really quickly, what has to be involved in that in terms of the notice, the copy of the rubric that's used, a summary of the manner in which student growth is going to be used, the procedures related to the professional development that's going to be given to teachers if you receive a needs improvement, and the remediation plan process if you receive an unsatisfactory. So that's all that has to be included, same as it was last year. And also for those other central office administrators out there, just a reminder that similar notices have to be provided to principals by the first day of student attendance also, with respect to all of that. You have a little bit more room with respect to when you have to do the student growth piece. You have until October 1st to identify that, but those notices still need to go out to them as well.
Great, very helpful. So then looking at the big picture, people have a lot going on. Do we have to do evaluations at all for teachers this year?
Well, I'll take that and give the bad technical news first, and the answer is yes. But the rest of this discussion this afternoon is going to focus on what alternatives there might be. I mean, we recognize the enormous strain and workload that's on our administrators and evaluators, and as a practical matter, we think that there are ways we can find ways to at least, if not totally eliminate, which we would advise against totally eliminating, but can reduce the load that goes with evaluating all that who would otherwise be evaluated in a non-COVID world. So we are recommending that non-tenured teachers be evaluated under the regular evaluation plan with whatever modifications are needed to make it work in whatever your instructional environment. We think that that tenure decision is so important, and having it accurate, defensible, is just it warrants, it almost mandates keeping with evaluation of non-tenureds. Where we think there's flexibility is on the tenured teachers, and again, we'll get into that and a few different ways that could be approached through agreements with the unions. So that, I think that big picture, that's where we've landed and are going to focus the rest of our discussion today.
Great. And what are the practical obstacles for districts completing evaluations this year? So I'm thinking student growth, teacher practice. How do they handle those things? Nicki, what are your thoughts?
Yeah, absolutely. So yeah, Todd laid out the sort of components to an evaluation. Obviously, there are going to be different practical issues with both. So the first is obviously the student growth component. So everybody has to have a student growth component in their evaluation plan. And I think one of the obstacles that districts, I've already heard about from districts, is that a number of the assessments that they would typically use to formulate their student growth scores just weren't completed last year. So they didn't do an end of the year NWEA assessment. They didn't do classroom assessments at the end of the school year. And so the question is sort of, what do you do with student growth if you don't have the typical metrics that you use? And, so one of the things that we're thinking about is whether you could use alternative student growth metrics. And certainly, and this is some of the reason we talked about some of the committees, your para committee could sit down and formulate how to amend or alter your evaluation plan to utilize the assessments or the metrics that you have from last year. And, you know, the question then becomes, if you can't reach agreement, what happens? And I think our reading at this point is that a district could implement some changes to their evaluation plan even without final agreement. But hopefully what you're doing in that committee is trying to figure out a path forward on student growth. And then of course there's the teacher practice piece. You know, I think our perspective at this point is that observations can and should be taking place. I know there's been some discussion that we've heard about whether or not Danielson is appropriate for the remote or a Danielson-like model. Obviously, the districts that are doing hybrid have opportunity to evaluate teachers in person. At this point, we don't see, there's no prohibition against evaluating teachers in a remote setting. Again, a discussion to be had certainly with the para evaluation committee, but certainly districts can look at utilizing remote synchronous learning as, you know, to evaluate teacher practice.
So now, what issues should we be thinking about with conducting observations in this environment? Shelli, what are the issues there?
Well, I think Nicki just raised one that we're kind of hearing about from some union folks, not all, but this idea that the school code talks about doing a observation in the classroom, and whether or not when we are in a remote environment, does that qualify as a classroom? Now, certainly I cannot imagine a situation in which a teacher could legitimately say out of one side of their mouth it is not a classroom and still be teaching and instructing on the other. So we are certainly of the opinion that if you are in a remote environment, that is the classroom that you are looking at. Now, how you look at it is obviously going to be different, but I think that's one piece of it, is really making sure everyone understands that concept. That's the classroom. If you're using a platform like Zoom or something similar, making sure that the administration has the ability to pop in on that classroom the same way you'd have if you're walking down the hallway and doing those informal check-ins. Now, certainly teachers should be aware that's going to happen. Teachers should be able to see that you've walked in or have entered the classroom, but certainly doing that the exact same way that you would have done it if you were in an in-person instruction environment. There's also been some discussion related to the videotaping of classes. We have had a number of questions from clients as it relates to, is this a student record? Is this permissible to do this? What notice has to be given to the students? What notice has to be given to the teachers? And, you know, certainly I think that there are many districts that are moving forward with having, if not all of their classes recorded, a portion of them recorded, so the kids can go back and watch maybe an important section of that class, and making sure that the union is likely to have some interest in discussing whether or not that recording that's kept can be used for evaluative purposes. For those districts who are not recording but just are live streaming, certainly that is just like any other classroom that you'd be able to evaluate the teacher's performance in the same way. So those are really the blocks that we're seeing so far, that I don't think any of them are hurdles that can't be overcome to continue evaluation process this year.
Yeah, and I would just like to make, I think that's exactly right, Shelli, and I just wanted to make the point also that, you know, I think it is so essential that administrators do have access to those synchronous learning environments that kids are going to be in, both for the evaluation piece, but also just in terms of typical administrator responsibilities to review and monitor teachers, you know, irrespective of the evaluation process. And, you know, we want to make sure that we protect that right, exercise that right. And of course, you know, in a situation where you may not be conducting formal evaluation for some of your tenured teachers, you certainly want to make sure you're still observing those teachers. And if something comes up where you have to adjust a teacher's practice, or, you know, in a more extreme situation, discipline a teacher, all of those rights still exist within the remote setting. And so administrators should be making sure that they have access to and are popping in just as they would in a, you know, as they walk down the hallway, as Shelli mentioned.
I just want to add that, you know, I love our clients. They're so wonderful. I just got a text from one of my favorite superintendents that said that Danielson just released her, let's see, framework for remote learning. So for those of you who were following Danielson, apparently she's already put something out now that we're likely all to be looking at to really look at how this evaluation piece can be done. So it's very timely. Wanted everyone to know if you haven't already received notice of that. So.
Yeah, we had someone from in our chat say the same thing. So we do appreciate the person listening also cluing us into that. So we'll take a look at that and get more information there.
Yeah, thank you for that tip. So what about labor implications? Are there bargaining obligations here, Todd, that are going to come into play? I know the answer is yes. So what are they?
The answer is yes, and I think we've already really touched on it when we summarized the labor law implications. And I think we'll really get into that more as we move through. I think one thing I do want to emphasize here is that taking a close look at your collective bargaining agreement is going to be very important as you approach evaluation. Shelli had mentioned, drop-ins and being able to do the video peaks, so to speak, and some collective bargaining agreements from the old days would have language that address sort of surveillance through the PA system and other things like that of teacher instruction. So there may be some pieces lurking in your collective bargaining agreements that really need to be carefully searched for, so that we've got all the impediments that might be thrown back at us as we deal with these plans. And obviously there's change of working conditions, even if something is not locked in, so to speak, by the collective bargaining agreement or the evaluation plan. We do have undoubtedly changes in working conditions that would be raised by the union, which can by themselves create an obligation to bargain. And then finally, we just need to try to sort through the mandatory and permissive so that we don't hurt ourselves in this year, and probably more importantly in years forward, by giving up some of our managerial rights with respect to evaluation.
So speaking of important documents, can districts should districts be thinking about amending their evaluation plans right now to adjust to current conditions?
I think that in terms of when you actually look at what the evaluation plan itself includes, I think that it's a matter of, for all the reasons Todd just talked about in terms of the components of it that you may have to actually bargain with the union versus that the district could make a decision to change. I don't really think there's going to be a need to change a lot of it. I mean, I've certainly heard a number of unions take a different approach and say there's no way we could evaluate, there's no way we can meet the parameters of our evaluation plan. But when you really look at it, it is. You may have to look at it through a different lens, some of the pieces, but I don't think that being in a remote environment, and certainly not in a hybrid environment, requires you to change some of those pieces. If you needed to, I think depending upon whether it was substantive or procedural would be as to whether or not you had to bargain it with the union. I certainly think keeping them as involved as possible is important, and making sure that your joint para committee, if you're touching on the pieces of student growth, are involved as well. To answer one question related to this that came in with one of our questions here as to whether or not you could determine just to do your professional practice for teachers and not student growth right now, I've had lots of districts ask, and I certainly think that would be the easiest approach. Unfortunately, not right now. Right now, we look at that would be in conflict with what the school code requires. And ultimately, those evaluations would be not likely seen as valid if it was ever challenged. So we might see something that comes out that allows you to do it this year, it being a very unique year. But as for right now, you need to make sure that your evaluations for teachers contain both components, professional practice as well as student growth.
Yeah, I did have a district sort of propose the idea of, defaulting the growth metric to a rating. That's an interesting idea. I think, if you get agreement with your union that, everybody, especially if you're doing building-wide growth, that everybody will get a proficient, or that there will be a growth score in that circumstance, and that it will default to a rating. It's all a little gray and murky here. I think that's an interesting idea. Again, obviously something that you would want to get agreement with on the union. Whether you could get challenged by that from a teacher down the road who gets riffed or gets a rating that they're unhappy with, I think is an open question. And obviously all of these have to be balanced. These risks have to be balanced about, against the realities of what everybody is facing in terms of just resources and time.
And I'd like to add that I think we should keep in mind that we really don't need an agreement to evaluate. I mean, the status quo is the evaluation plan that's in place and the collective bargaining agreement provisions that are in place. Where we may need agreement, or where we at least may need to discuss, are the changes that might have to be made to make this work in our COVID-19 world. So, I think that's a big picture piece that we should not lose sight of.
Yeah, I think there's a misconception out there. I mean, when the change in the law happened with respect to a default to excellent, that somehow there was a notion that, well, if you received an excellent last year, you got an excellent this year. And I think people are missing that interim point that it only defaults to that if you don't complete the evaluation process. There's nothing in there that indicates you can't continue the evaluation process of tenured teachers. So I think that's right. We have every right to continue to evaluate if we need to, or as we see fit for our teachers.
So you guys rained on the parade on the getting rid of the student growth component. Is there any part of the evaluation process that can be waived, Nicki?
It's a good question that I'm not sure I have a definitive answer to, but I'll sort of frame the question a little bit. So what we're talking about when we're talking about waivers is we're either talking about a statutory waiver or we're talking about a regulatory waiver. So in terms of the statute, what the waiver statute essentially allows is for districts to seek waivers or modifications of statutory provisions, essentially through ISB from the General Assembly. What the statute says about evaluation pieces is it says you cannot seek a waiver on the student performance data, the student growth data piece being a significant factor in both teacher and principal evaluations. So you can't waive the student growth and you can't waive the 4 categories that teachers and principals have to be rated on. What's interesting is if you go to ISB's website, their description of the pieces of the teacher evaluation process that you can't waive is arguably broader. And so I actually have a question into ISB about that, and we can certainly update folks. We also have somewhat of a timing issue here because likely the General Assembly has to act on the waiver report by October 1st. So if folks are seeking statutory waivers, it has to be done relatively quickly. Likely that's not the route that, if the issue is student growth or the evaluation components, likely you're not going to need to going down the statutory waiver front is not the way to go. The regulatory waivers go directly to ISB. And so, if there's a piece in the regulations that are, throwing up a roadblock for you as a district, but are not present in statute, that's something that can be looked at. Again, there's sort of a timing issue here as we start going through and we're getting ready for the beginning of the year and starting the evaluation process. But certainly if folks are interested in looking at that issue or there's something particular they're running into an obstacle on, we're happy to take a look at whether there could be a regulatory waiver that would work.
All right, so we've talked about a lot here. Shelli, what are we seeing in terms of how districts are resolving these issues at the local level? Do we have any practical advice on what to put in MOUs or otherwise on how to resolve these kinds of concerns?
Sure. I mean, I'll start the conversation. I'd certainly be interested in what Nicki and Todd are seeing as well. I think in terms of how we're seeing districts resolve these issues is that, I'll say carefully whether or not there is the legal ability to do so. They are making a decision not to evaluate their tenured staff during this school year and let the default happen with respect to what rating they received, which would have been in 18-19 now. Now, we'll talk a little bit about what needs to be an MOU related to that, but aside from that part of it, I am seeing many districts, whether they're doing that or not, making sure that to the extent that they're making any modifications to their evaluation plan, that they're putting that in writing in an MOU, very clearly stating it only applies for the 2021 school year, that they still have the right to do drop-ins and evaluate informally their teachers, that is not something that even if they have, for instance, decided they're not going to evaluate probationary staff, it does not limit their ability to drop in and take action if they see something in that class. And I think you have to remember that even if you don't evaluate a teacher, if they do something in the class that can be disciplined, you can still take disciplinary action for that. And a lot of questions I'm getting are around, well, our teachers are required to do this much synchronous learning. What if we find out that they're not doing that and you're saying they're not going to be evaluated? What do we do? And the answer to that is that's insubordinate. If you've told them they have to do a certain amount of time, so you go through the discipline process with them instead of the evaluation process with them with that. So I think that's one piece of it. And then related to that, more for probationary teachers, making sure that you are not giving up and you're expressly reserving your ability to non-renew them at the end of the year, regardless of what the evaluation processes look like. So making sure that's in there as well. And then lastly, before I turn it over to my partners here, the idea that you are reserving, to the extent there was any bargaining related to this, that you're reserving your position as to what's mandatory and permissive outside of the world of COVID for next year. So Todd, I know you have some thoughts on the idea of whether or not they can actually not evaluate tenured staff, and if they decide to do that, what should be in the MOU?
Shelli, I think we've gotten in probably more than a handful now of draft MOUs from our clients. So it seems like this is now bubbling up in a lot of places. And so the MOU provision we've seen frequently is simply a sentence or two that says that a certain category of teachers, most often tenured teachers, will not be evaluated this year. And it's just that simple. The problem with that language is that it flies right in the face of the labor law provision that says that a collective bargaining agreement can't contain a provision that violates or is in conflict with the statutory provision, like the duty to evaluate tenured teachers every 2 years. And the labor law language goes on to say that an agreement of that sort actually is unenforceable and void. So that's the sort of the legal issue that we're facing. We think that a creditable argument can be made that particularly with the recent amendment to provide for the default reinforce the default provisions with respect to the absence of a rating in a particular year, that the legislature at least tacitly recognized that in this situation we could have an MOU with a provision that says that we're not going to evaluate a certain category of teacher this year. So who's going to challenge this? I mean, the teacher, obviously, with the MOU, the union should be out of the box there. I suppose individual teachers could claim somehow that their right to be evaluated, to have attain an excellent rating where they may have had a provision before, diminishes their RIF standing. We could have parents and taxpayers come and try to utilize the provision of the labor law because they're unhappy with whatever the instructional plan that the district has. Those are probably pretty unlikely challenges, and if a district decided to take on a provision that the tenured teachers, for example, aren't going to be evaluated this year, there's some decent arguments to make there. Probably another approach would be for the MOU to provide that that the union will not object to a decision by the district not to evaluate a particular category of teachers this year, and that way we don't have the MOU does not violate the statute or give a handle to argue that the labor law language plugs in, and the board would simply know that the union is okay with that, and then the district would take action to decide not to evaluate tenured teachers, for example, this year. So there are a couple ways to approach it in an MOU, and again, we're not going to sit here and tell you that we can't find a way to make it work, that certain teachers aren't going to be evaluated. Just one other point, another category of teachers to perhaps not to exclude, or a right to preserve, along with what Shelli was saying, is the ability to evaluate a tenured teacher where the performance or conduct during this year warrants a needs improvement plan or a remediation plan. And we'd also, even if we give tenured teachers a complete pass this year, we wouldn't want to have to wait 2 more years to undertake the evaluation process to get to the point of doing a needs improvement agreement or remediation plan. So that's another factor to consider as we look at the implications of giving tenured teachers a pass on evaluation this year.
Yeah, I would say, I think that we've always had the right to evaluate the year after. I know some unions kind of push back on that idea. So if you have a union that takes that position, it might be worthwhile to include that in MOU as well, that you're reserving the right to make sure that you can evaluate that tenured teacher the following year if you need be. Sorry, Nicki, I didn't mean to cut you off.
No, I was just going to note that we got a question, which I think Todd answered, but I think is worth repeating, which is what is the penalty for allowing everyone to default? What would be the possible recourse? We couldn't think of anything. They can't make us retroactively evaluate everyone, right? And I think that's right. I mean, what we were talking about in terms of if you have an MOU with the union obviously at that point likely isn't going to seek or can't seek recourse. The issue becomes, and again, unlikely scenario that you end up riffing teachers down the road and one teacher indicates like they default to a proficient and they make the claim that had they actually been evaluated properly, they would have had an excellent and wouldn't have been subject to the RIF. Again, somewhat of an attenuated risk, but I suppose it's there. The other possibility Todd raised was sort of a taxpayer or parent suit. Again, you might get some grumblings from parents. Seems unlikely that you get legal action. I suppose that, ISB does have the power in the, in their audit every year to, the recognition audit to note if you haven't followed statutory and regulatory provisions. Given what we've heard out of ISB, I think it seems unlikely that they're going to come down with a hammer on a district, and likely it will be short-lived anyway. You'll start evaluating as soon as you're back in person. So again, what we're trying to sort of avoid is, entering into MOUs that later the union could claim are unenforceable or bring a challenge. But, some of these risks are fairly attenuated at this point.
So before we go on to our, I'm going to ask you about principal evaluations, but I wonder if we shouldn't address some of the open questions that we have that we've received so far. I know that you guys have hit on a few of them, but we did get the question of whether there are any thoughts on the is there a timeline for which of these discussions with the union for when they need to conclude? What if we cannot reach agreement on critical issues?
Well, I'll jump in on this. I don't think that there is any particular time. There's no timeline that's specified in the labor law or Article 24A. There may be some timelines that are in a collective bargaining agreement or the evaluation plan, which call for, certain steps before observations are made, or that the process has to be started and completed by certain dates. So I think those would guide the thinking on that. Ideally, before the first round of observations takes place, we would have had the necessary discussions with the union and the joint committee, and where an agreement was needed, hopefully we would have reached an agreement. So get started, start looking at it now, and I would guess that we probably got the month of September to work through these things.
Great. And then we received a question of if we were to not evaluate tenured teachers, are districts pushing back the evaluation cycle 1 year or planning to evaluate all tenured teachers the following year? Shelli?
Well, I think this is kind of what I was touching on earlier, is to say that, if you are not evaluating those on cycle this year, if you've made that decision, making sure you're reserving the ability to do that next year, that there are some unions take the position that we can't evaluate more often than the regular cycle unless there's been a needs improvement rating or something like that. So I would say it'd be very difficult for your administrators to evaluate everyone next year. So if you were pushing everyone forward, that would mean you were evaluating all tenured staff and all probationary staff. And our larger districts are just not going to be able to do that. So reserving the right to certainly evaluate anyone that the administration determines needs an evaluation the following year, and keeping the ability to do that.
And then Todd, we had a request if you could repeat the language about what should be in the MOU about what the union agrees to. So the union will not blank the decision.
Yeah, that the union would not object to a decision by the district not to evaluate a certain class of employees, like non-tenured teachers. And obviously, I think there would be an understanding, although it would not be articulated in the MOU, that it was the district's intention not to evaluate non-tenureds.
So then our next question is a great segue. We had a question about thoughts on the administrative evaluation process. So Nicki, can you tell us, are there any issues specific to principal evaluations that we need to think about?
Yeah, I mean, I think, folks are familiar with how they evaluate their principals. We're not going to go into too much detail. Obviously, Shelli mentioned the notice requirements. By October 1st, you have to inform the principal on which assessments and measurement models and targets you're using in terms of growth. There's a certain number of observations you have to do. You have to do 2 formal. The only thing that I will say about administrator evaluations that I think bears some thought in terms of this is that you do have some more flexibility with administrators and, with your principals and your assistant principals. If you are concerned about your student growth metric and you want to adjust it based on assessments from last year, you obviously have more flexibility to do that with your principals and your assistant principals. You just have to let them know by October 1st. Obviously, that's not something you need to negotiate with the union or discuss in the joint para committee. So a little bit more flexibility there. But the issue with principals is, statutorily you need to evaluate them and assistant principals by March 1st, or else their contracts, you risk their contracts rolling over for another year. So certainly if you have principals that you're concerned about, assistant principals, you want to make sure you get those evaluations completed. Again, understanding that you probably have some more flexibility in terms of the individual components of the principal evaluation.
Now, do we think, Shelli, that there will be any new legislation that will help us out on any of these evaluation issues? What are we seeing from Springfield?
Well, we're hearing that there's likely going to be something that comes out. We've been lucky that sometimes when we mention it does come out that day or the day after. So hopefully someone from ISB is listening. But I certainly think that districts would like some further guidance as to if there's going to be a way to work through this that is sanctioned by ISB, that comes out certainly sooner than later, so that when they're working with their unions through this now, they don't have to go back and readdress it because the decision or position of ISB is different than what they had. So we'll see. We've heard it is coming out soon. Not sure whether it will be or not.
And then Todd, let's talk for a moment more about non-tenure teachers. How are we thinking about evaluation and its intersection with the right to non-renew?
Well, the court cases have essentially said that if the district doesn't follow its evaluation plan, it still retains its discretion to non-renew a non-tenured. But that's not a good practice. And another reason that we think non-tenured teachers should be evaluated this year. That provides the basis for a non-renewal decision, particularly with respect to a fourth-year probationary teacher, where we have to state the reasons for non-renewal. And when we usually draft those statements, we draw right from the evaluation documents. So I think conducting evaluations for our non-tenureds just makes sense. And I'm not sure that other than some of the things that we've touched on, the student growth issues, how you do the observations, and so on, I don't see a lot of modification that needs to be made to an evaluation plan to go forward with the evaluation of non-tenureds this year.
So then shifting topics slightly, can you remind us, Todd, about the new appeal process for teachers who receive an unsatisfactory?
Sure. We haven't we haven't had a lot of contact from clients on this subject, and our sense is that it may have been, and perfectly understandably, pushed aside as administrators have struggled with the daily changes in what their instructional plans are going to be. But the school code was amended to provide for an appeals process for a tenured teacher who receives an unsatisfactory rating. And it's a very convoluted process. Statute was one of those that I think popped out of nowhere, and it was not well done. But it involves both negotiations with the unions and also work with the joint committees. And there are just a lot of intricacies and pitfalls in the process that need to be addressed. Now, the process for the appeals was to be in place this school term. We don't. Some might interpret that at the beginning of the school term. We don't. But certainly before there's an evaluation of a tenured teacher that is going to result in an unsatisfactory rating, the process should be in place. So it's something that, it's been on the back burner, it seems, or maybe districts have gotten taken care of it, but it's something that should be addressed in due course this fall.
Yeah, and I just want to remind people again about our reference guide, our checklist. We have some documents on this, so if you guys are looking to start that process, feel free to reach out to anybody on the webinar or any of your favorite Franczczek attorneys, and we're happy to help you through that process a little bit. I actually wanted to answer a question that came in just because we were just talking about principal evaluation, and it says, if there aren't any new principals in the district and no issues with your current ones, can you not evaluate principals or assistant principals this year? So again, the statute requires you to evaluate your principals. So I can't we're not going to sit here and say, just, you don't need to do it. Obviously the major ramification of not evaluating your principals beyond just giving them the feedback is the potential for their contracts to roll over. And obviously, if that is not a concern, that lessens the impact should you not get to evaluating all of your principals. But certainly, by law, you are required to complete these evaluations.
That actually ties into another question that we had, Nicki, related to evaluating of teachers. And the question specifically is, even though an MOU that conflicts with or violates a statute is considered void per labor law, is it still permissible? That is a really tricky question. Obviously, this is a webinar for information, not legal advice. I want to say that from the outset. But what I will also say is that, the four of us have been dealing with this since March, as all of you have. And what I have learned after being a school lawyer for 21 years is that I have never had to talk to clients more about weighing risk than I have over this time period. You have to figure out a way that you are going to make your school run and be the most effective for your teachers and for your students. They've been out of school for so long. Your teachers have been out of the classroom for so long. Now working into a whole other environment that we're ever used to. So I don't want to say in this format that it is permissible or not permissible. I want to say talk to your counsel about it and understand what the risks are and what the benefits are of moving in one direction or another.
And Shelli, I'd just add that we think we can construct arguments that would support, if the decision is made not to evaluate non-tenureds, for example, we believe we can construct arguments that would support that. But we should talk about the risks and contra arguments on that.
Yeah, and we certainly understand that what's being balanced here is, we can talk you through the legal liability ramifications, all of that. What you all are balancing of course, is the need to ensure that there's some level of accountability, there's a level of consistency in teacher practice and your principal practice, because obviously in this time period, parents are, the expectation, particularly if you're full remote, is that you're going to see, strong performance on your teachers so that kids in this environment can continue to learn and to grow. On the flip side, we understand that as Shelli mentioned, you're just trying to open your schools and run some educational program this year as we get through this tumultuous time. So that balance, where you strike that balance, is going to be very district specific. It's going to be very specific to the conversations that you're having with your union, where you guys can fall. We can assist you with trying to think through the legal ramifications and as Todd said, the language that we can craft so that you are falling within the confines of the statutes. But again, trying to balance those to hit the right balancing point for your district and for your teachers, students, and parents.
And we're also not suggesting that anybody should get a pass for poor performance or misconduct. And to go back to what Nicki and Shelli have been saying, those tools remain fully available to the district during this process and can be used appropriately to deal with performance and conduct issues that might otherwise normally have fallen or been more likely to fall within the evaluation process. But we should look at this year as nobody is entitled to a pass for poor performance or misconduct.
We received a question about, as it relates to administrator evaluations, that some have heard that districts can use student growth from last year for evaluations during the 2020-2021 school year. Does that contradict the statute, which requires student growth to be part of the evaluation? Anyone have thoughts on that?
I want to make sure I understand. Is the question, Jackie, whether they thought that that's what they heard us say or that that's what they've heard kind of out in the school community?
I think elsewhere, yeah.
Yeah, I think as Nicki probably touched on a little bit when she was talking about administrative evaluations, I think you run the same risk there potentially if you are relying not on student data that's in accord with what the school code requires for principal or administrative evaluations, if you're just relying on what you had from last year. But I think there might be a way to get creative about it. Nicki, Todd, I don't know if you have any other ideas on that piece of it.
Yeah, I would have to look back. It's been a bit of time since I looked specifically at what the student growth component requires for principals specifically, and what flexibility you have on the metrics of that. So I think it'd be worth taking a look at the regulations again, and seeing what flexibility that you have there. And obviously, in terms of your discretion, you have a little bit more leeway. So certainly we would want to fall within the regulations and the statutory provisions and try to get our student growth targeted in that regard.
Yeah, this is an area, there are a couple areas, and this is probably one of them, student growth, where some help from ISB and perhaps some legislative corrective action should be taken. I mean, we've got the override session is in early November, I think, is the next time the legislature will be in session. And, so there is some time to look at legislative and regulatory corrections or action that would permit some of the things where we have questions as to whether they can be done. One plea that we would ask for is that things not drop out of the sky, because we found that, like with the appeals process for unsatisfactory ratings and some of the other pieces that have come out in an emergency basis, they haven't been particularly well drafted and create issues among them by themselves. And so I think the importance of management groups being able to participate in the legislative and regulatory process is something really to be stressed this fall.
Well, Todd wouldn't let me talk about the breadth and depth of his experience when I was introducing him, but I think we all really appreciate those thoughts, and I think it's a great place for us to end. Thank you all so much for joining us. We look forward to seeing you next week when we will be talking about lessons learned. Again, if you have any lessons you'd like to share, if you'd like to join us, let us know. Reach out to us at allmarketing@franczek.com. And thank you everyone for joining us. Until next week, please take care.
Bye.